Oops, I didn't hit record on this computer. Perfect. So our legal webinar for today is going to be on how to navigate commercial leases for small businesses. And at this time, I'm going to allow William to share his screen. So give me one quick second here.
Okay. Oops, here we go. Okay, we're ready there.
Perfect.
Oops.
So you should be able to share your screen now.
Oh, okay, good. Here we go.
I'll stop
Wonderful. Hey, welcome everyone. Thank you for joining in. And Amelia, thank you so much for translating. Just let me know if I need to go any slower or speed wise it needs to be different. So, and I already see a question in the chat, and I will be addressing questions at the end, but already an identification that there's been some issues with working with landlords at this difficult time. So yeah, we want to try and give you as much information as we can on helping you with that. So Amelia, are you ready to go? Yep. Okay, well, let's go, guys. So welcome to our legal webinar. I mean, the first thing we always say is yes, this is legal information for you, but doesn't satisfy what's needed for an actual individual attorney-client relationship or anything constituting legal advice. And that's where you can tap our office hours on a regular basis. We do those in English and Spanish. Oh, I'm sorry, Amelia, should I be pausing? Amelia, should I just keep going?
She said yes to continue.
Okay, good. All right. So I'll have some information at the last slide about how to, where the website is to sign up for our office hours. But this is where you can get some more individualized attention going forward.
Yeah. And Bill, I want to confirm the interpretation is simultaneous. So
Oh, okay. So I'm not even hearing it.
correct. Yeah.
Oh, okay. I got it. Okay.
Yeah, she's really
All
talented.
right. Oh, so efficient. This is wonderful. Okay. Well, thank you, folks. And thank you, Amelia. All right. So our agenda today. So I want to give you some, takeaways right at the beginning. Most important advice. We got a little slide, one slide for that. Then I want to make sure that you understand a little bit about what leases are about and what are some of the most important lease clauses. Now, many of these things I'm going to be highlighting are for people who are about to get into commercial leases. So this is will hopefully give you some consumer protection information, as you're trying to negotiate a lease. But then also at the end, we're going to be talking about, if you're having trouble with your landlord and maybe there's been some notice or something that you think there's going to be an eviction or something like that. We'll cover that more toward the end. But first, we want you to be sort of as smart as you can about being a consumer of commercial leases. So we'll go over that first, then get into potential default situations and disputes. Okay. All right. So first thing you should know is that leases need to be in writing. There is an exception for leases that are less than 1 year. So possession of a piece of property, piece of real property for a year or less. But then after that, the only thing that's really going to be protecting you is in writing. And I would say any lease should be in writing, really. And you should also know that these sort of verbal side agreements that people might have, you should really pretty much treat those as they don't exist. Because if it's not in a lease itself, the landlord can always deny that there is such a thing. And generally, these leases have a little clause at the end that says, everything we agreed to is in this lease. It's called a merger clause or an integration clause. So that just means that it tells the judge, don't even pay attention if the tenant claims there is an oral agreement. Okay, so just get everything in writing if you can. Now, another thing you should just know is that commercial leases, generally what we say in the law, it's the four corners of the lease that will govern the situation. Whereas in a residential context, there's a little bit more state law that's out there that sort of says, okay, residential tenants have these rights and those rights. But in the commercial context, yeah, you pretty much look at the commercial lease and tenants and landlords are, are free to negotiate pretty much anything they want on things, okay? let's see. All the oops, there's a little typo there. You should understand all the terms. Okay, um, and then of course, if you have any questions, have a lawyer review it before you sign in there. And yeah, generally what we say in terms of negotiation is, anybody who pressures you, says it's now or never, or take it or leave it, or those sorts of things, generally it's not a good idea to sign something under those circumstances there. Right? Most people regret it. All right. So negotiation is really pretty important. All terms and clauses of this lease are generally negotiable, even if it says up at the top, and you may see this, you know, California Chamber of Commerce standard lease or something like that. Well, that doesn't make it, the Bible or something. This is something that is, these are terms that you're going to have to pay attention to and follow. And so all the terms in it are negotiable, even if, or let's say, put it this way, all the terms are legally negotiable. If the other side is saying no, 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 well, you have to decide whether you want to deal with people like that. So let's see, definitely, you know, questions about who's responsible for what. We're going to get into this in a few minutes, but, repairs, for example, who is supposed to do that? Is it you, and then you deduct the cost on your rent, or is it the landlord? Yeah, all of these different things, are the way that you tell when somebody is in breach, when you know who is supposed to be doing something and they're not. Okay. But here's think of some bad scenarios when you're starting to read these leases that you might sign. Think of some bad scenarios like this one, for example. Here you are, you're in your tenancy, you're in your place, and the AC breaks down with 1 month left on your lease, and you were planning to leave. Well, the cost to replace the system is $10,000, and so if your lease said that you would fix this, there's going to be no prorating here. You're going to have to come up with 10K, even if you're leaving, a month later. So yeah, that's the kind of thing. That's kind of a worst case scenario that you have to pay attention to here. Okay, so let's start talking about what leases look like a little bit. So you think about the base rent, which is usually based on some kind of square footage. Okay, now they may have given you some square footage when they told you about this listing. I would take your own measurements just to be sure. Just make sure that there's an agreement on the size of the space, because you got to know, for example, that if you are in a space like a mall or something, well, when malls come back, but when malls are there, your space and the cost of the common area maintenance would be based on the size of the space that you have. So if it's off in some way, then yearly you should not be paying, that amount that's based on, more than what you really have there. Usually there's this terminology called net leases. Okay, so these are single net, triple net, double net. So single net, you just got to know is, okay, so you take your base amount that is essentially taking the landlord's mortgage and paying a portion of that. Then the additional single net lease would be property taxes added on there. So property taxes that the landlord has to pay. Then double net, property taxes plus building insurance, triple net, property taxes, building insurance, and then even some of the operating expenses of the building. So just know that there's this terminology out there that also identifies what you're responsible for. Okay? Now here's some questions. When do you have to start paying the rent? It may be that you agreed with your landlord that certain maintenance or even repair or refurbishment was going to happen before you took possession. Then the landlord spills over, keeps going, doesn't have a date for you when you can take occupancy, but might still require you to start paying rent even if you can't take the space. Certainly you want to know some things of what's included in the rent. As I said, the single, double, triple here, but maybe common area maintenance, as I was saying, if you're in a mall or something. And then this idea of your rent increasing every year. Certainly that's something you want to know up front. And then, this issue that's so important right now, do you have to pay rent even if you can't occupy the space? So we'll get into more of these in a few minutes here, but here's some other important lease clauses. So the first one was, of course, what is the rent? and then some things about payment and when payment is required. Certainly term. Now, this is something that was in the chat there. Term of lease, of course, states how long you're entitled to occupy the space. Now, here's a point. A landlord could sell the building out from under you there. Well, if you had a subordination and non-disturbance term in your lease, that means that the new landlord would have to honor the same lease that you had with the previous owner of the space. Okay, so make sure you get that part in there. Now, options are really important for commercial tenants because, of all of the potential changes that you're making to the space to make it work for your business. Of course, be advertised where you are, and so marketing is so important to make sure you're not changing your location very often. So that's why so many people sign these leases for so long. They just want to make sure that they, can continue to market and make changes to the space without disturbance. Now, that's where options to renew come in. Uh, Critical part is to know that there is a window of opportunity that you will have under your lease to say, landlord, I want to renew my lease, and that is very strictly, usually very strictly enforced by a landlord. So even, an hour late on 5 p.m., you forget, you remember at 6 p.m., you might have just lost the opportunity to extend. Okay. And of course, you want to send a written communication to the landlord that clearly exercises that option. Say, under this clause of my lease, I am exercising my option to renew the lease. Yeah, that's what you want. Now, there are some things about determining the rent during this extension term. Maybe it doesn't exactly say. That's the problem, because if it says you can extend but doesn't say what the rent will be, there could be an argument that it's not legally binding there. So to be determined on your rent, I would say that we exercise our option to renew the lease. But before you get to the last second on the date to do that, make sure you find out what it is that is going to be the extension rental term. Not just the amount of time you can extend by, but the rental amount, of course. All right, now if there's no option to extend, well, here's some strategies that we might suggest. So the first thing I would say is probably, look and find out what the fair market rent would be for that space. And right now, I think people are probably in pretty good shape because there's so many spaces lying open right now. And so a landlord, it's smart for them to try and retain you in the space because it's not really clear if you left that they would be able to fill it there. So first thing I guess we'd suggest you do is, if there's no clear option to renew, I wouldn't do this at the last minute. I would say, start talking to them. The chat person said it was still a couple of years off or a little while off. Yeah, that's when to start talking about it. And that's where you would say something like, well, I've looked it up on Zillow or one of these market rate apps that are out there. My rent, right now is this. I've seen on Zillow it could be this. Okay, well, start saying that I wanted it. I will give you fair market value for it, or maybe plus 10%, plus 5%. Where the property value is rising. I don't know what it is in Fresno or your part of the valley right now, but this is where you might even do a little research on projected rents over the year or something like that. Zillow or some of these other engines will help you figure that out there. But then, of course, propose this to the landlord. Now, if they turn it down, then you might say something like, well, what about maybe a shorter term than what I have now? And if you're doing that, well, then maybe you'd be entitled to lower rent, but then maybe just the current rent during this there, or maybe with a less, extensive increase if you're going to do it at a shorter term. You could also offer to take less space. Certainly a number of spaces these days are contracting. Maybe the landlord has a reason that they want part of the space. Well, yeah, they're trying to be flexible about that. Let them have the extra office in the back or something like that if it can be squared off. So, All right, now, and by the way, the chat person, Consuelo, I think it was, we could talk about this afterward, or maybe even individually about your situation. So, okay, so you got extension. Now let's talk a little bit about the condition of the premises if you're coming in. Okay, certainly inspect the premises before signing the lease. Um, by the way, I've seen different things about this. Even my son had this issue where he saw on the web, even on a regular listing. Now, this was for a residential, of course, but I've heard this in the commercial context too. You know, something that said, "Oh, you know, it looked like a really good rate" or something like that. And then it was a little cagey about who was the landlord, and the person said, "Well, I will meet you at the place, and we will negotiate the lease there." And then he realized when he met the person there that they were just sort of saying, they wouldn't exactly say who was the landlord. They showed that they had a key, but they wouldn't answer other questions. And so we pretty much identified quickly that this was somebody who had gotten the key, was simply just going to take your money, a big deposit check, and then, you know, it wasn't really their space. So just be careful, you know, make sure you inspect the premises. Yeah, don't have anybody tell you this is a great deal, but you got to sign right now and you can't see it, but here's some nice pictures, you know. Okay. So inspecting the premises, you know, key things: heating, air conditioning, making sure they're in, you know, working while you're there. Asking if the premises are up to code. Um, Certainly, you know, if you identify repairs, tell the landlord before moving in and try and put those in the lease, maybe as an addendum saying, you know, it is agreed, you know, upon signing here that the landlord will undertake these particular repairs. Um, you could have an independent party conduct an inspection. You know, it usually costs some money there, but if you're going to be in this space for quite a long time, you know, it might be a good idea to have somebody do that. Yeah, now this as is clause, you got to worry about that a bit. You see, landlords want you to sort of say, I'll take it the way it is right now. And there could be hidden things, things that are going to blow soon. So if the landlord is pushing you into this and you really want the space, well, you can then maybe say, I suppose, in an addendum saying, okay, well, I'm not going to, I will sign it, but I need a statement that it is in compliance with all laws. And if it isn't, then I'm not going to be responsible for the fixing it up to bring it into compliance. Okay? And I'll show you in a minute. This also importantly deals with ADA issues, ADA, you know, the Americans with Disabilities Act, because there's important repairs or fix-ups that have to be done with the ADA that you should not be responsible for. Okay. Another important lease clause, you know, improvements to the property. Okay. Well, if the landlord is making the improvements, okay, well, probably a good idea to do that before you get in. Let's make sure we have a deadline, you know, and if the deadline is exceeded, then there should be some understanding that you don't have to pay rent until you get into that space. Right? For tenants improvements, okay, well, here's, you know, generally your improvements are going to improve the space, so the landlord should be encouraging that. That's where you might get this thing called a tenant improvements allowance, which simply would be probably a break on rent until the value of the tenant improvement was realized by the landlord. So that's something you could work in there, free rent while you're doing your improvements. Maybe you get some allowance, a sort of a special fund that the landlord sets aside and says, okay, well, yeah, the carpeting looks like crap here. Okay, well, I'm going to give you $500 to fix up the carpeting, and you know you can then use that fund to do this there. Here's another part: removal. Okay, so things like, oh my goodness, like cosmology law. Wait a minute, which one's a cosmetologist? Cosmetologist is the one. Cosmologist is the astronomer, right? I'm sorry, cosmetologist, people who, yeah, do, you know, hair, nails, makeup, things like that. Okay, well, if you've got tables and you've got you know, swivel chairs and stuff you put in the floor, well, one thing you gotta know is that those things tend to become what's called fixtures. Fixtures, and fixtures means these are items that are attached to the property, that the tenant has attached to the property, that actually become part of the property. Okay. And the standard for that is, can you remove it without significant damage to the property? Okay. If it turns out, yeah, it's become a fixture, then, I guess what I'd say to you is to make sure that there's some language in the lease saying that, yeah, all these really expensive swivel chairs, the landlord's going to buy them from you at a discount or something at the end of the lease. I know there was a rent we did, and the tile floor was just awful, and so we told our landlord, oh well, we're going to put in this tile floor here, and the landlord was like, oh, that's great, that's wonderful, and then 6 months later told us that the end of the lease was, you know upon us, and sorry, I'm not going to pay you anything for this tile. So anyway, there is questions about if you did make significant changes to the premises, whether you would have to restore it going forward. So, after you leave, so that's something to think about. Actually, this reminds me of something I should have said earlier on the written part. So let me just sort of harken back to that. Remember, I was saying have everything in writing. There was a client that we had about 3 years ago. It was a cosmetologist, cosmetologist, and she had a space. There was a barber in the space. There was somebody else who did nails. There was somebody else who did skin in the space. And so what was happening to her was she said, "Oh, this is my space here. The landlord's not fixing the air conditioning, and it's really hot. It's Contra Costa County is very hot in the summer, so it's affecting my business." And so we said, okay, well, let's see the lease. And she gave us a handwritten note from the barber, who was apparently the original lessee on the space. Okay. And actually, there was a written that he had gotten from the cosmetologist. That's right. And the cosmetologist had gotten a written assignment of the lease from the barber. And so as you can imagine, the situation here is now somebody who the landlord doesn't even know is in the space through these written things is now going to be coming and complaining about the air conditioning. Well, that's not going to work. So just know these writings that have to follow here. Yeah, they can't be just sort of like scribbled on a piece of paper. You're really going to need, and by the way, with the situation, she told me that yeah, the landlord hasn't really been watching who's in the space and all of that. So that's a very tenuous situation there. So I guess what I would say to you is, if you are going to sign the lease, make sure that you got approval from the landlord. Make sure that there's a writing that the landlord has actually signed going forward. Okay, let's see. ADA, yes, the Americans with Disabilities Act. Maybe you folks have encountered this a little bit. Okay, but the main thing you should know is that the ADA that requires the removal of barriers to accessibility for folks, in wheelchairs or walkers or things like that, that applies to both landlords and tenants. Okay, and tenants generally, my sense of it is, since they don't have as much control over the building space, it really should be the landlords paying for this. But sometimes landlords will try and throw this cost onto you because it could be significant, really. I mean, a new bathroom, a new ramp, all these different things. And private individuals who may be helped by attorneys could come around and just sort of say, well, there's no ramp here. I went in, there was no bathroom that I could use. Okay, landlord and tenant, you are both, subject to this lawsuit. So, as I said, landlords try to pass these costs along to tenants sometimes in this language that says tenant is responsible for complying with all laws. Okay, well, you be smarter. You will then, when you go into this commercial lease, say, okay, well, does that include ADA? Okay, well, a couple of things. First, there is a requirement on the landlord to disclose whether there's been one of these ADA compliance inspections that's done in the local by the local authorities. It's usually called a CASP inspection. I can't remember exactly what that stands for. But anyway, so you ask, was a CASP inspection, was an ADA inspection done before signing the lease? Okay. If there hasn't been one, then maybe there should be a clause that you put in there that says, okay, landlord will conduct, will be responsible for the ADA barrier removal if the premises are found to be out of compliance. So, again, you might want to check this out before you move in. Just it's going to be easier to upgrade, before you move in there. All right, maintenance and repairs. Generally, the landlord is responsible for maintaining the building's structural elements. So if the roof leaks or if, a wall starts crumbling or something, okay, and the common areas as well. But the tenant is generally going to be responsible for maintaining interior stuff. The light fixture goes bad or, something like that. So I guess I would say generally the good idea here is to make sure there's a list of all of the things that could, anticipatorily be going wrong, and make sure it says, okay, in one column, landlord will fix when this happens, tenant will fix when this happens. If there are big items, certainly think in terms of, landlord at least amortizing that over time, if it's a big thing. Yeah, like sprinkler systems or security systems or stuff like that. And then as I mentioned in the earlier example there, some prorating if you're about to leave the lease situation there, so that you're not carrying over, things that you're not responsible for really. Okay, so there's this assignment. I guess I could have mentioned it at this point. So there's the assignment, and then there's also this thing called subleasing. The main thing you should just know is that assignment is more of like handing over the lease to somebody else with the understanding that if they default, then you are still on the hook. Okay, so an assignment is like, I'm giving it over to my friend here who's going to take over the space. They're going to interact with the landlord. Okay, they are going to pretty much act like me in this situation here. And of course, I'm still on the hook unless the landlord lets me out, and then you'd be a full assignment in that situation there. Okay. Now, the way I understand it is that landlords cannot withhold consent to an assignment unreasonably. They can't just say no, never, never, never. If you present them with a proposal with somebody who has a good credit history, they're going to be using the space for not, I don't know, truck rallies or stuff like that, then, there's generally a sense that a landlord should take that assignment there. Similarly with subleasing, although landlords are more interested, I think, in subleasing because then they really have you on the hook. You generally tend to be the one interfacing with the landlord, and there's no real changes that they see other than a new person in the space there, because the tenant's going to pay you rent in this situation, whereas in the assignment, the tenant will pay the landlord directly there. So, this is definitely a clause to look at before you take a lease, especially if you have a new business. Maybe your business won't quite make it. 50% of businesses close, new businesses close in the first 5 years, even before the pandemic. So I guess what I would say there is make sure that you built in the idea that, potentially you could sublease this 10-year lease if you need to going forward. All right, well, just a few more clauses. Insurance. Okay, definitely you want to be getting commercial general liability insurance, but I would also talk to a broker. Again, I'd always buy insurance with a broker, somebody who can shop amongst a number of policies for you, not just somebody who's like a State Farm agent who can only, who's a nice person possibly, but can only sell you State Farm insurance. So get a broker, ask them if there is something like a commercial tenant's insurance. So that would help you take care of the cost of things if, for example, somebody accidentally poked a hole in a wall, or maybe again, something that you have to repair breaks down, then you'd have some insurance that could cover that. Now, there's this other thing called a waiver of subrogation. This is a kind of a sticky clause, and what that's about is, let's say you've got a place and a consumer comes walking into the space. They use the stairs. Maybe there's a ramp somewhere else. They use the stairs. The stairs are kind of crumbly, and so they slipped and hurt themselves, and now they have medical bills that need to be paid. Okay. If it's relatively clear that the landlord was responsible for fixing that thing that caused the damage, well, what would normally happen would be there'd be a claim on their insurance policy for the medical bills. Maybe the landlord would dispute it, something like this, but it would be between the person who was injured by it and your landlord. Well, a waiver of subrogation, if you've got it in your lease, would say um, landlord's insurance company can't then come after me for something that the landlord should have done. Okay. Um, so the waiver of subrogation is in the lease. So it says essentially we'll each have our insurance companies pay for what we're responsible for going forward. Okay. Zoning laws. Oh, yeah, this didn't come out very well, but look at this. This is beautiful. It's like art here. This is the city of Fresno's existing zoning map there. And you can see, look at all those colors that they got there. Well, okay, so certainly check the zoning plan before you sign a lease, because it may be, I don't know, you want to raise chickens. Well, maybe there's only certain places in Fresno there you can raise those chickens. And even home use of your property, meaning home use in a business, like you're doing accounting or you're doing, cooking food or stuff like that. Yeah, maybe you'll also need a home occupation or home business use permit from the local. So just make sure you go to the zoning office, make sure that you've got the right permits and stuff, or can get the right permits easily before you sign your lease there. Okay. There is this thing, if it turns out that you did sign the lease, but the zoning permitted uses don't allow your use, there is potentially a way to get a variance. It's called a variance, and what you'd have to do is get your neighbors to go along to a hearing and basically say, oh yeah, it's okay, my neighbors don't mind, and it's not like we're putting toxic waste in the air or something like that. We're just, we have a little kind of business that is outside of the plan right now, but won't dramatically affect my neighbors. Yeah, maybe you'd get a variance for something like that. Okay, now we're in the home stretch, guys. We're starting to talk about default, disputes with your landlord here. Okay, default means that somebody on the lease has not fulfilled their promises on the lease. Usually two kinds, failure to pay rent is sort of an economic default. And then a non-economic default is sort of anything else. I don't know, you didn't stop when the landlord said you couldn't use the property for this purpose, and in the lease it said you had agreed not to use this property for that purpose. Okay, well, both situations, if anybody breaks promises, then default happens potentially. Now, one thing you want in the lease, if you could get it, is this notice and cure period. Okay, that means that you're only in default after you get notice from the landlord. And of course, then you'd also get some days to cure it, for example, like 3 to 5 days for non-payment of rent, or 10 to 30 days for failure to perform one of these non-economic obligations. That means curing it, that means actually fixing it, and then there hopefully will be no problems going forward. A question it might be at this point, let's say that the landlord, let's say you were doing something in the space that was prohibited in the lease, but then the landlord, knew about it, said just, sort of wagged their finger and told you not to do it, but they didn't actually send you a notice. And now it's like a year later, and then later they say, oh, but I told you. Okay, well, that could be a case for saying, well, you let me do it. You knew it was going on. You didn't, tell me anymore not to do it. You didn't send me a writing about it. There could be an argument there that they've waived that right to enforce that promise in the lease if they've knowingly sort of let you continue doing it for a long time. Right? All right, so you get some disputes potentially. Well, hope not, but here's a couple of things. There are two kinds of sort of ways that you would resolve things. And first, I definitely would say overall, just always attempt to negotiate. Because what's going to happen is that the court, if you actually go to court, they're going to ask you, like, first question, did you try and negotiate a settlement in this situation? Then you've got dispute resolution measures, mediation, arbitration. Mediation, hold on just a second. Oops, sorry, hold on. Sorry. Mediation is where a mediator, a third party, potentially helps you negotiate that settlement, but they can't actually impose a settlement in that situation. And I point out here that we actually have a free service for that. So if your landlord is at all interested, willing to mediate, we tend to say no lawyers involved. We just want the landlord and the tenant to be, working things out. But just email us at newbusinesslaw@berkeley.edu if you're interested in this free service. Or you can set up something in the community. I'm sure there's a good community mediation program that Sandra can help you find in the Fresno area there that's usually low cost on things and all that. But also at that same community mediation place, they probably have some arbitrators too. Arbitration is like private court. It's always cheaper than private court. That means a private person that the two parties have agreed to can resolve the matter after hearing evidence from both sides. Okay, so would definitely encourage any of these things before you go to court, because courts can be very expensive. Now, in a minute, I'll mention that, I can mention it right now, is that from what I understand, Fresno is still under a moratorium for lease commercial tenant evictions. That means that their courts aren't even hearing these, notice of non-payment of rent or suits for eviction. But actually, Sandra was going to call the city. They were on their lunch hour when I called to try and check. Maybe Sandra, you could put that in the chat if at the end. But basically, if there isn't a moratorium, okay, then here's what happens. Usually, if you didn't pay the rent, then you would get a notice of non-payment. If you didn't pay, if you do pay, that can usually cancel this. It's a 3-day notice to pay rent or quit. And then, of course, eviction would tend to follow if the rent is not paid. There may be some violations of use in the lease. These are those non-economic promises and stuff. So I guess what I would say is if there's no reason at all, okay, if you have a month-to-month tenancy, then the landlord can simply give you a 30-day notice and get you out. But this is why you'd want a multi-year tenancy and an option to renew, so that they couldn't just come along and kick you out, 30 days notice. So it's this 3-day notice, as I said. They have to show proof of service that it actually got to you, in usually certified mail. And as I said, full payment takes care of it. You have a summons and a complaint, and usually then you'd want to go to an attorney and have them look to see what was in the complaint and all of that. You have 5 days to answer. Remember, it includes weekends, but not court holidays. Okay? And that's where you'd add some defenses. Look, in this situation here, we'll tell you some defenses in a few minutes there, but you'd add any defenses there. You just don't want to not answer, because at that point you can be in default and be a very quick turnaround for the landlord there. And then the court has to set a trial date within 20 days of receiving your answer there. Again, one of the main things you want to make sure in an eviction proceeding is that if you settle, then you don't want anything about this potential eviction proceeding to go on your record, because that could mean you couldn't rent. Sorry. Sorry. Don't know what I got in my throat there. Sorry, guys. Okay, so if the landlord wins, then you can expect to be, out in about 2 weeks. The sheriff will come by, post a 5-day notice. If you go past 5 days, the sheriff will then lock you out, and then you have 15 days to claim any property that's left there. Kind of a tough situation. All right, so the last thing we're going to cover here is, well, what's happening what could you do if right now you're having trouble getting along with your landlord on stuff? And one thing you should know is that landlords used to have a lot of leverage, and so they could have some swagger about this. They could just basically file this notice to pay or quit, and then they sue for unlawful retainer. It's kind of summary. There's few eviction defenses, if you haven't been paying. And then, there could be also a lawsuit for damages for past rent or for future rent as well. And so, if they can get to court, they usually have a lot of tools at their disposal for this. But because there's a moratorium, now a number of landlords don't understand really that they don't have any leverage anymore. Now, as I said, county or city imposed moratoriums are really up to the city or county in which you live. So if you are in, Chowchilla or something, make sure that you've checked in Chowchilla about their particular um, eviction moratorium there. And what I did see on the Fresno site was it said something like, as soon as the moratorium will continue through the emergency that has been declared. And once the emergency has been declared over, then it'll continue 90 days after that. So I couldn't, unfortunately, when I called the city, I couldn't get any answer from them about whether it was still in place, but they did say that the emergency was still there. So I think, you're in probably good shape at this point in terms of the evictions right now. All right. So what you should know, though, is that landlords are looking at this and they say, well, I'm not getting any payment right now, but I don't want my space to go empty. Look at all these other spaces that aren't being filled right now. I'm not getting any money to help me pay my mortgage, but I guess a little money is better than no money. And then you, of course, would want to see some kind of uh, certainty in what you'd have to pay. So if you would say something like, well, I'll pay, there's this outstanding amount of this amount, and every month my rental amount is this much. Okay, well, until I reopen, I can't pay anything off on that, accumulated debt. I will pay you, I don't know, a quarter of my rent at this point each month, as that's all I can afford right now. And then when I get going again, then we can start tackling that past rent after I start at least being able to pay the full rent every month. See, those are the kinds of negotiations you want to do. So we've seen things like deferred rent, some even forgiveness of rent, okay? Certainly applications of security deposits to cover rent. Maybe you'd even say, okay, well, look, to help recoup the amount that's in, arrears here, meaning not unpaid, we'll say that I'll give you 5% of sales every month to then pay that down. Okay. So those are some different things. Now, there may be conditions that are added to that. So you have to continue your business. Landlord doesn't want to agree to this and then, suddenly you're filing for bankruptcy or something. So there could be some clawback if somehow you just, negotiate this and then file for bankruptcy. Then they could say, okay, well, that forgiveness of rent is out the window there. All right. All right. Well, so I said landlord's mindset is going to be, well, gee, how is this tenant ever going to be able to get going again? What's this? I have a roller rink here, client here. Is roller rink ever going to be possible in the pandemic? What's the risk that the tenant will file for bankruptcy? And in that case, I'll have to be, behind every other creditor that came along. Let's see, what else? Can I possibly release the space? The tenant, of course, there's again going to be some preference, unless the landlord is frankly stupid, to say, all right, it's better to have the devil that I know in the space and try and get some money coming in, but I'm going to keep in my pocket, the possibility of coming back later. That's usually better. Now, one thing I do hear about, guys, you should just know, is from tenants attorneys, they often say to me that, look, landlord attorneys are vicious and awful, okay? And sometimes they don't even tell the landlords what settlement offers you've given them, okay? I've heard of tenant attorneys saying, look, when I go to court, I actually yell in the area where we're doing our settlement negotiations outside of court. I yell what the settlement offer is, so that then the landlord's attorney can't claim that they didn't, weren't able to get the landlord's input on it because they're usually on the other side of the room. And so I guess what I'm saying is that we have seen now a number of landlords just sort of saying, I'm going to take them to the wall. It doesn't matter. You're getting, a letter from my lawyer and papers tomorrow. Well, if you got your moratorium in place, you can say, I'll look forward to it, but they're not going to get it, and they're not going to get into court. And right now, the timing is probably, we're talking at least a year to get into court on some of these different things. So So they have an interest in negotiating right now, and that, hopefully you can use for some advantage there. So there are some defenses potentially. So let's say you were in a mall and an anchor tenant left, like Sears, or maybe they're not around anymore. So like Nordstrom or something like that, they left. Okay, well, when you signed your lease, you were told Nordstrom would be there. Okay, maybe that's a defense in this situation. There are these things like frustration of purpose, or force majeure just means, well, something happened during the lease that we couldn't have planned for. A pandemic might qualify for that, I would think. And maybe here's another thing. The landlord, I moved out, and yet the landlord didn't even try to, rent the property. Okay, well, that's failure to mitigate damages, although that's limited a little bit by this one, the civil code section. Now, there is one other thing you should know, and there's this thing that you can sort of avoid court for a landlord if you've actually created this thing called a deed of trust, because that is instead held by a trustee and not by a court. And so that means that they can then just go to the trustee and say, the tenant violated this deed that I gave them. And then the trustee can say, oh, yes, you're gone. So just know that if you are getting pressed and somebody has what's called a deed of trust, they can maybe move faster there. All right, guys. Well, that's pretty much what I have to cover with my presentation. There's a few resources, I might say. There's certainly local, I think it's Central California Legal Services. I don't know if they do commercial tenants. I should probably find out about that. But as I said, we do have our mediation service that can be helpful for you. The Lawyers Committee for Civil Rights, that's what I have here, is they have this fair and just lease that you can compare to the lease that you're given by your landlord. Just email us here if you want a copy of it there. That would give you more of a sense of what a consumer-friendly lease would look like there. And then NOLO Press is always good resources and stuff. So, top 10 reminders. Just remember before we go, okay, write everything down. Read every term and negotiate every term. Don't give in to gotta sign it now, don't read it, don't visit the place, anything like that. Don't respond to that pressure. Make sure you know what rent is due, what's included in the rent or not, understand the term and any options to extend. Definitely know the condition of the premises, including whether ADA has been assessed by a local evaluation or not, or whether you've built that into the lease. Know who pays for those improvements or fixing things. Definitely get some insurance. And maybe have that backstop of assignment or sublease, okay? And then finally, make sure that there's some notice and cure periods in your lease for default. All right, that's what I got. Okay, well, just make sure if you have questions, you contact us. This is our information website to sign up for services. That's those office hours, 11 to 2 every Monday, Wednesday. Oops, I'll go back for a sec. Email us at that address there. We also have this online legal library for entrepreneurs, which is very helpful, has a lot of free legal materials and templates and stuff that you can use. So, and look for us on Facebook and Instagram. All right, guys. Well, there you go. Some questions that people might have. Hope that's helpful. Let's take a quick look at some of the questions.
Yeah, so one of the questions that we have, first of all, thank you so much, Bill, for today's presentation. And I like that last slide as a quick 10 steps reminders, right? So that's really great for the tenants here.
And Amelia, I'm sorry, it looked like you asked me early on to speak up. I hope I spoke up enough. Sorry, hope that was okay. Looks like we just had one question here, but of course then we can have other questions before.
Yeah, we can answer the question on the chat box, and then I have another one that was sent to me of a scenario question. Or maybe we could start with that scenario question.
Sure.
Since you just covered the information about the notice, the 3-day notice regarding either start date or, so the question here is the 3-day quit notice dated, is it 3 days before the delivery, or when does the 3 days start?
Oh, okay. So 3-day notice to quit. The 3 days begins, as I understand it, on the day that it is delivered to you. Okay. And as I understand, the 3 days also does include weekends, but does not include court holidays, the way I understand Now, if it says something different on the notice, then of course, do that. And then again, I wouldn't mess with it. If there's any way that you can pay within that 3-day period, definitely do that. Um,
Perfect. Thank you. And the second question here is so the question reads, how could I better exercise my options to renew my lease,
mhm,
given that they have a few years to remove and moving to a new location, it's not a consideration or at least the best option in this scenario.
mhm.
And so the question is, how can they negotiate the option to stay at that location?
Yeah, yeah. And in fact, that sounds a little bit like Consuelo's situation. Let me just double check here. Current lease
That is
expires.
that question. I just try to reiterate differently.
Oh, you tried to reach out. Oh, it sounded so similar. Yeah, there you go. All right. Well, yeah, and definitely if you could put in improvements on the space, yeah, you're wanting to see if you can get something for that, or at least stay longer so you can get the most benefit out of that. All right. Well, I guess one of the first things I would say is, um, so that you're saying that the landlord has not responded to a request to talk about this. If they haven't responded to a request to talk, I mean, it's really good that you started already. Uh, it sounds like the lease expires in a couple of years. So it's in that situation, it could be that the landlord is still hedging their bets a bit, if you know what I'm saying. They're sort of saying, well, yeah, I see a lot of spaces that are open. Yeah, right now I would give her that extension if she wanted it, but in 2 years, maybe it's going to be a boom. Maybe people are really going to want, and then they're going to want more. Then I can get more rent and stuff like that. So it may be that it's just not quite ripe for them yet, and that gets puts you in a tough situation because you can't force them into the situation here. And if your lease did not provide for any kind of recoupment of improvements, meaning that they have to actually pay the value of it, leftover value of it if at you when you leave. Let's see. I guess I'd say in this situation, try and get them to start talking by saying, "Look, I've first the value of the property right now is this, okay, and the rent that I'm paying, I paid it regularly. I'm a solid tenant for you here. That's not as good as many places out right now. I've been paying this, or I will be paying it once COVID is over. Um, so I guess I would say first try and sort of remind the landlord how good a tenant you have been. Okay. And then I would say, and look, I'm willing to lock in for, you know, this amount plus some increase. Now, I went to Zillow or I went to the local Chamber of Commerce and I got some information that had a sense that the rents are going to be, 10% higher next year or 5% higher next year. Let's build that in. I will say that I would rent this place for another 5 years or something like this at 5%, increase every year or something like that. So just, try and give them this something that they can't quite ignore, something that's better than your situation right now. What else I would do? Um, I would start now. I would start early so that's not like something that they can wait you out and then just not give you the right to renew.
Mm.
What
And if I
else?
can add, Bill, to this conversation,
Yeah, please.
the question here is, well, not the question, but the response here is that the landlord is not willing to even meet to discuss.
Yeah,
So in
yeah,
this type of situation, the options for the tenants
yeah.
are very limited.
That's tough. Well, I would certainly email them, or excuse me, not email them. I would certainly send them something like certified mail or something so that that they got the proposal there. Um, I suppose, is it a single? If it's single landlord, it's tough. If the landlord is part of like a group of, a management company or something like that, then you might have a little bit more leeway to go to other parts of the management company, maybe even a board member or maybe even an ombudsperson for the management company or something like that, who might be more reasonable than this one person who's denying you there.
Yeah, it is
Um,
a out of town landlord,
Out of term, yeah, Nord, okay. Well, I would certainly make
single family.
sure that you sent your proposal. I would research the proposal really well. I would maybe write a little letter and to say, I've really appreciated being in your property here, and I am a good tenant. I think this is something that we could work out for our mutual benefit. Here are the terms that I'm willing to, these are opening terms that I might be willing to negotiate going forward. And yeah, see if you can lure them into the conversation. I mean, unfortunately, the only other thing I guess I would say is the improvements. If these are things that are detachable, I suppose you could get a repair person in. And if, yeah, these were like expensive chairs that you put in or things like that, looking to see if there are ways that those can be removed without hurting the space or yeah, if any of these improvements are stuff that you can take with you, that would be another way you could maybe realize the value. But I realize this is going to be tough for you because you got your marketing that you're doing. This gives you uncertainty about whether you can continue to market this space. Your customers know where you are, and this could create uncertainty. Yeah, unfortunately, in negotiation though, yeah, you got to have somebody come to the table in this situation there. I suppose here we go. I suppose other people who can vouch for you. Um, maybe, let me see what else. Oh, I know. Why not say, hey, I'm ready to do some other improvements on the space. If I can, recoup that over time, that would be another thing, I suppose. But yeah, unfortunately, if the other side is just not even listening, then there's not a lot of. I guess I'd say make sure you have a contingency plan for pulling out. Um, yeah, that's just a really tough situation. I'm sorry about that.
And we can connect after the conversation today to see how we can further communicate in this situation,
Yeah. No, let
like
me
our
put
office
in the
hours.
chat
Yeah,
there. Yeah, I'll just put in again our website to sign up for
office hours.
law.berkeley.edu /NBCLC is our website to sign up for office hours to discuss
Mhm.
further.
And I do have another question, actually, a situation that happened earlier this morning.
Mhm.
So, for example, a business that it's, a startup business, they're excited to get started and they're wanting to, for example, they sign the lease before getting the permit, right? Which is a common practice. A lot of, not common, I don't say it's a common practice, but it's the common situation that a lot of startups do, right?
Yeah.
What are the rights in case that area is not zoned for the use that they have intended, but they put down the contract, they sign the contract, and
Yeah,
the lease.
yeah. Well, let me see. I suppose there's two places I would go for that. First, I would explore the possibility of a variance. I would go to the zoning board office, explain what happened, and then certainly identify with them what would be the process for seeking a variance. And again, if your property use is not, I don't know, you're storing toxic waste or big emissions or stuff like that,
Mhm.
a variance isn't really out of the question. You just have to make sure your neighbors are okay with it because they'll come to they get notice of the hearing that then the zoning board decides whether to change the use, the labeling of the space, the allowances of the uses for the space. And then your landlord, your neighbors will come, and that's where if your neighbors don't really have any problem with it, it's you know pretty pretty straightforward actually to get a variance like that. Now, if you can't get that, um, I don't know. I guess I would maybe argue if you pull out and the landlord still tries to sue you for the money. Well, I guess first thing I would do then is before you get to that point, I would try assignment and I would try subleasing. Those are things that you could potentially control, and the landlord again needs to not unreasonably deny that. Okay, so there's another option. And then if it does get into court, I suppose one defense that I might give would be what's called frustration of purpose, meaning there's no way that you would have rented this space if you had known that you couldn't use it for that business purpose. Now, it may be that the court says, well, you should have checked on that before you signed it. But, that kind of multi-year default of money and windfall for the landlord just because somebody didn't check a permit. I don't think courts are generally wanting to see that kind of a windfall for the landlord. Um, so I guess I would say, and of course, if the landlord gave you any thoughts of, oh, well, you could definitely do this here, or something that sort of gave you the sense that it wasn't going to be a problem to get a permit, that's another defense I would use for sure.
Got it. Thank you. I don't see any other questions here in the chat box, but we will share again the contact information to connect with the team at New Business Community Law Clinic.
Yeah, and I'll also send a copy of this PowerPoint, of course, to you, Sandra, so you can share it with people. Mm-hmm.
Absolutely. And I do want to remind that the presentation is being transmitted live through Facebook. And I checked Facebook. There's no comments, no questions or comments there. So we are okay with moving forward and coming to our closing remarks here. So thank you so much, everyone that is joined at the moment for the Zoom meeting. And thank you, Bill, as always, for the presentation. And our next legal webinar will be next third Friday of the month. So that's going to be May 21st. I can't believe we are already halfway almost through the year.
Okay, sounds good. All right, thank you, everybody. And do contact us if we can be further helpful.
Yes, so thank you everyone for joining us. Our contact information here for the foundation is on the screen. And of course, if you need to connect with the team at Berkeley Law, you can give us a phone call and we'll make sure to make that connection and also share with you the resource to sign up for their one-on-one office hours.
In English and in English and Spanish too.
That is correct. English and Spanish services. So I hope you all have a wonderful weekend. Thank you for joining once again. And we will look forward to connecting with you in the next webinar. Thank you.
Okay. Thank you.